We now come on to the English legal system. So these are how to report courts in England and how the court system works in England. Mostly applies in Wales as they're very similar, but in Scotland and Northern Ireland they pretty much do their own thing. So if you are in Scotland and Northern Ireland, this is just covers the English legal system and mostly Wales as well. So this is how it works. This is kind of a rough diagram. So you can see you've got the Supreme Court at the very, very top, but at the bottom of the rungs you've got Magistrates Court, which can also deal with civil offences as well, civil and criminal. It deals with both, and then you've got county courts going up, Court of Justice, Court of Appeal in the civil, and then Magistrates Court, Crown Court, Court of Appeal, and then obviously everything can go up to the Supreme Court the very end. So that's just kind of a structure, although magistrates can sit as criminal and as civil. So the courts, Crown Court is for indictable only offences. They have incredibly lengthy sentencing powers. They can sentence people to life in prison. They can also sit for as appeal courts for magistrate offences, but somewhat of a risky move. For instance, with the Liam Stacey case, which I covered, Liam Stacey was sentenced to 56 days, 28 days in prison, 28 on licence, for racially abusing on Twitter Fabrice Mwamba and people on Twitter, and he appealed, and the Crown Court heard the appeal as it's the next court up. It's quite a risky move, only in the sense that the Crown Court can sentence you for a lot longer than the magistrates can. So the magistrates can only sentence you for 6 months. Crown Court says, actually, it's not long enough, we'll sentence you to a year. So, somewhat of a risky move. And the people who sit there are called judges. The Magistrates Court is for all crimes will appear in magistrates, and then they will go up to Crown Court if it's serious enough. Summary offences will be dealt here. Either way offences may be dealt there, or they might be sent up to the Crown Court. Accused, especially for summary offences like speeding, tickets, fines, the accused doesn't even have to appear. They can just post their guilty plea and the fine in, and it's all taken care of. So particularly speeding tickets, you just send in your guilt and the fine. And the people who sit there are called magistrates or justices of the peace. So what to do, or rather not to do in a courtroom? Turn off your phone or put it in silent mode. It has to be non-obtrusive to the courtroom. Do not make recordings, electronic recordings, any form of recordings, or sketches. Particularly, don't try and be a court sketch person, because they do have those people in to do court sketches. Don't make recordings or sketches. It includes the entire building. It's not just the courtroom. So particularly, don't take photos in corridors or inside the building. It doesn't apply outside the building, so you feel free to take photos outside the courtroom as people go in, so long as they're not jury or witnesses or there's restrictions on reporting. Turn up on time. Many a judge will berate you for being late. Don't talk, or if you very much have to talk, try and keep it as low as possible, because if you intrude on the court may ask you to leave. Follow the instructions of the usher. If you don't know who the usher is, just ask anyone in a wig and they'll probably be able to tell you. Ask the usher, or there will usually be an office there if you're unsure about which courtroom will appear in what, and kind of where you should go and what you should do. When the judge enters the courtroom and leaves the courtroom, they will say all rise, and you must stand to your feet as a mark of respect to the court. Don't report legal arguments don't repeat legal arguments that are made without the jury being present. You can get into a lot of trouble, particularly if it's decided that the jury isn't allowed to know that information, and therefore the public. In court, you should either learn shorthand or learn to write really fast. Word for word, particularly in statements made, is really needed. Because you can't make electronic recordings, you can't record voice, you can't take a dictaphone, you can't do a lot of things. You must either write incredibly fast or learn shorthand. What you can do in a courtroom, you can sit in the press bench if you identify yourself as a journalist or a student journalist. That will allow you to sit in the press bench. You can live tweet courts now, although you'd be very careful about how you do it. It must be unobtrusive to the court, it must only be with the jury present, and the court can just ban it for any reason. If they just don't feel like it, they just say, no, no tweeting. And you can only tweet for journalistic purposes. So checking your own Twitter might be a bit, posting for your own personal Twitter might be a bit funny. Don't post photos, descriptions of the witnesses, jury, or obviously sketches or anything of that nature. Lord Judge, who ruled on whether people should be able to tweet from the court, said on the day of the judgment, he said, you may Twitter as much as you like from today. So you are allowed to tweet, but make sure you try and make it a balanced and unbiased version of events. Reporting in a courtroom is, I'll put in the description link, a link to the BBC Academy for the College of Journalism about how to report in magistrates and crown courts, and there's a lot more. It's a very interesting insight in how to, in exactly what to do and how to just physically get around in the courtroom. Contempt of court. Don't annoy the court, they won't appreciate it. Publishing material that might affect a trial, make a jury more likely to find a defendant guilty or innocent, influence a witness, vilify witnesses. So vilifying witnesses is where a report might be so abusive or vilify, literally to make villains of the witnesses, that witnesses would no longer testify. So particularly in high-profile cases, if the witnesses are challenged particularly very strongly or criticised very strongly in the press, it may be considered contempt of court. Strict liability, so again the idea of actus reus, you might not be aware you're committing contempt of court, but that's no defence, you're still doing it. And anything that kind of proves a substantial risk or impediment to active legal proceedings, that also comes under contempt of court. It can only be initiated by Crown Court or higher. Fortunately for student journalists, this is a great rule to remember. Rule 5.8 of the 2011 Criminal Procedure Rules allows the right to obtain details of a case over the phone as well. So if you couldn't make the court, if you couldn't make it to court, you couldn't see the case or whatever, you can always ring up and ask for the details, and the details they can give you. We'll come on to a second. The court officer will have most of the details, so long as it's not more than 6 months ago, and there aren't any reporting restrictions, particularly with children. So on. They will be able to give you the dates of any public hearings, the alleged offence and any plea that has been entered, any decision that the court has made, and the identity of the parties, the judge, the magistrate, the accused, the lawyers, the witnesses. Obviously, only use the information that you need to. Obviously, don't go printing witnesses or jury members' details, as that might get you into contempt of court. The law specifically does say that you must pay any fee prescribed, but journalists usually aren't expected to pay any fee. So when does a case become legally active? There are kind of essentially 5 stages to a case. When someone is arrested, when they are charged with an offence, if they plead not guilty, it then goes on to a trial, and if they are then found guilty or not guilty, that's the verdict stage. And particularly if it's a Crown Court offence, it's still legally active even until sentencing. So with magistrate offences, it stops verdict. With the Crown, it keeps going until sentencing. So when the person is arrested, the arrest warrant is issued, summons is issued, someone is charged orally. If none of the above happens, sometimes it might not. It might be when the written charges are served to the accused. Particularly if someone appeals, it becomes legally active again. So clarify, make sure you're very aware of where exactly in the stage of the investigation is. If someone is helping the police with their inquiries and they're not under suspicion, it's not legally active, but you've got to be very careful of defaming them. So always ring the police station and say, well, actually, is this person under arrest? Are they just merely helping with inquiries? The case stops becoming legally active when the person is released without charge, unless they are released on police bail. There's a very clear distinction to make. Release without charge means that they're free to go, whereas released on police bail means they're free to go up until the point where they're caught, and until they're due in court. And obviously bail can be revoked at any time. It stops being legally active if the arrest warrant isn't served within 12 months, or the case is discontinued, or there is a verdict or a sentence in Crown Court. They're found unfit to be tried, usually through mental disease or defect. The judge prescribes that the charge should lay on file, or an appeal hearing is completed, or obviously when a defendant dies, you can't prosecute the dead. Reporting on police investigations is very tricky. There are 3 chase levels. So there was Chase vs News Group, Newspapers Limited in 2002, and the judge prescribed there were 3 chase levels, as it were. So level 1 is that the person is guilty of the criminal offence, and that is relatively safe to report on, being no defamation because they have been found guilty of criminal offence. Level 2 is that someone is reasonably suspected of the offence, so quite considerable care should be taken to make sure you're not defaming, and make sure you stay with the police and ensure that you're getting all the updates at the same time. Level 3 is that there are grounds for an investigation, which is the most dangerous in terms of defamation. So obviously, as a investigation may increase and go through the levels, you'll be much safer in printing an article. It is defamatory to say that they are suspected, as it implies that there is conduct on the person's part which warrants suspicion. So particularly in level 2 and level 3, it's somewhat unsafe. But do always check with a lawyer or until it goes into the legal system, and then to be absolutely sure. The 1981 Act helps, which allows journalists to help police in investigations and identifying suspects, is around mainly so that if they put a "can you help" and then say there's a mugshot of a man and say we're looking for this man in relation to a crime, and then you can safely report on that, but no one has actually been prosecuted. That's never actually been properly tested. So the case study I'll give you in police investigations is Joanna Yates, who was strangled in Bristol in December 2010. Is murdered by strangulation. The landlord, Mr. Jeffries, was arrested in connection with the offence, but later a Dutch engineer, Mr. Tabak, was arrested and then charged and later found guilty of the murder. Mr. Jeffries was released and faced no further action. The Daily Mail and the Sun were found guilty of contempt of court for reporting information to prejudice a trial. This information was because the jury weren't allowed to find it. Obviously, this serves as a practical example of if the jury aren't allowed to know, the public aren't allowed to know or shouldn't know. So it's the fact that Tabak had watched strangulation porn was considered very prejudicial and was excluded from the jury. So the jury weren't allowed to know it until after the trial, and then the papers published after he was found guilty that he had watched strangulation porn. So if it's not allowed in the jury, it's not very safe to report on legally. ITN were barred from the police conferences after tweeting about the fact that Tabak had watched strangulation porn. They were also charged with contempt of court, but it was dropped after they removed the offending tweet. Jeffries sued a lot of publications and won for a substantial sum of money. So it's always, even though they're arrested, if they're never charged and then obviously someone else was arrested and charged and convicted, that person, even particularly if you say, well actually they are, if you imply that they're guilty, a lot of the time they can sue you and win successfully. It's not really a defence, but if you're incredibly incompetent, you can use a Section 3 defence. Not knowing a case is legally active. So the definition of this is the person responsible for the publication, having taken all reasonable care, did not know and had no reason to suspect when the material was published that relevant proceedings were active. If you don't know when proceedings are active, check. Always check. Phone or email the police press contacts, search in your area for us as South Yorkshire Police Press, and there will must always be a press contact. You'll be able to even just double check, just because you don't want to have to use Section 3 because it makes you look a bit stupid. If the police don't have any information, or it's gone into the court system, phone the magistrates or the Crown Courts under Rule 5.8, as we discussed earlier, and ask them for the details of when the hearings are, if there's any plea entered, if there's been any sentencing or court's decisions. You can usually always search for, if it's particularly a high-profile case, you can usually find more details online as well, or in newspapers, or you can be able to see whether reporting restrictions apply to other people, and if they do, obviously they'll apply to you as well. Be careful on prejudicing a jury, particularly using previous convictions of the accused can be somewhat prejudicial. Accusing the accused of dishonest conduct, if publishing evidence linking them to the crime before the court case is finished would sometimes be seen as prejudicing a jury in contempt of court. Suggesting that they are either guilty or innocent, so trying to keep the coverage as unbiased as humanly possible. So the correct phrasing of something, of an article, would be that someone who had been arrested for rape would be a 21-year-old man has been arrested on suspicion of rape, or a 21-year-old has been accused of rape, or a 21-year-old allegedly raped a female student last week. So kind of always try and keep it as factual and as legal as humanly possible. Do not, under any circumstances, say the 21-year-old perpetrator was arrested for raping a student. The word perpetrator implies guilt. So any word, perpetrator, attacker, anything that implies guilt before they have been found guilty or may influence a jury. Also, Joe Bloggs was arrested for raping Jane Doe. You've named sexual offence victim, which is obviously against law, and at the time of the arrest, the police don't have to give you the name of the person who's been arrested, but obviously when it goes to charged, at which point that becomes public record. So when they've been arrested, it may just be a 21-year-old man has been arrested of rape. Always get the charge right. I can't instill this enough. Theft and robbery are very, very different crimes. Theft is, so for instance, theft would be pickpocketing, and robbery would be mugging, as robbery is the violent offence, and theft is the dishonest. It's the more dishonest without force or without the threat of force. Theft is deception without force. Robbery is theft with force. So, particularly in a breaking situation, or particularly when there's a court case, it will go through several stages. So in the first instance, you should try and make it as factual as humanly possible. So this was an article we used in Swansea just before I left there, saying a 39-year-old man has been remanded into custody after being charged with a sexual offence against a 21-year-old female student in Swansea. Very factual. Goes on to say, Lee Molloy was arrested by officers after the incident, which happened in a flat on King Edward's Road during the early hours of 5th of June. Again, very factual, not emotive. It's by the letter exactly what has happened. Molloy appeared at Swansea Magistrates Court this morning and was remanded until his next appearance on the 13th of June. Again, very factual, gives the information, and also says that the court case is continuing. A lot of the time you might see the case continues or the trial continues, and that's particularly making sure that people know that it's essentially the court cases are ongoing. The correct reporting, so ensuring that no emotive adjectives are used is probably always a good idea, particularly when there's courts and crimes involved. So, for instance, Joe Bloggs, 21, of Barber Lane in Broom Hill, has been sentenced to 15 years at Sheffield Green Court after being found guilty of the rape of an 18-year-old female student. Obviously, you can see where I've square bracketed out the brutal, unless someone has been quoted as saying that, and at which point you should put it in quote marks. Avoid very over the top or kind of any adjectives to try and keep it as true as possible to the legal definitions. The attack occurred near the East Street Live pub during Freshers Week. The victim described how Bloggs viciously, and obviously this is in quotation mark, so obviously this is what someone else has said in court and therefore protected by absolute privilege, attacked her after spiking a drink which left her unconscious with broken ribs and requiring a 3-week stay in hospital. Those are all facts. It's very factual. Bloggs had previously pleaded guilty to a sexual touching case last November and received a 6-month suspended sentence. So after he's been sentenced, the case no longer becomes legally active, and reporting restrictions no longer apply. So you'll be able to say actually he was previously convicted after he's been sentenced. The judge, a judge's comments are usually always quite fiery. Judge's comments are always quite good, saying, so in this instance, you preyed upon a defenceless girl in a premeditated manner, laced her drink and raped her. You have ruined her life. No punishment can make up for that. Obviously, this is a fictitious case, but sometimes you can pull out some of the judge's quotes and make them into headlines. So, Joe blogs ruins life of rape victim, for instance, putting it in quotation marks.